You know, there are certain things in life that we just keep putting off until it's too late. Estate planning and other aspects of elder care are two of those obligations to which you really owe it to yourself and to your family to take care of ahead of time. At the Nebenzahl Law Group, they understand how important this is, how to do it right, and most importantly, how to keep your family out of court. Coming up next, Andy Nebenzahl, an elder law expert, is going to tell you how easy it is to do this advanced planning and to avoid the pain which results from having to go to court when a loved one may pass away.
There are certain things in life that we just keep putting off until it's too late, and it can cost us. Estate planning and other aspects of elder care are two of those obligations to which you really owe it to yourself and your family to take care of ahead of time.
Estate planning and elder law involve the process of thinking through and documenting how you want to be cared for as you get older, what you want to do with the things you own when you pass away. The experience of a good attorney comes from what he or she has gained from assisting other families over the years and learning what's important, learning where the pitfalls of document drafting, for example, are. A lot of times there are a number of issues, very subtle issues sometimes, that a lawyer can help guide families through the numerous considerations and decisions that you need to address. The most important thing is to engage in a discussion with a professional who knows how to ask the right questions that are applicable to your family, understands your family. It's not a cookie-cutter session. Documents aren't cookie cutters. It's important that the documents you create reflect accurately your intentions and the needs of your family. I began to develop an estate planning practice actually after my mother passed away. A year or so before she died, she got all of her children together and brought us to her lawyer's office and said, okay, this is what I've done. Here are the trusts that I have. Here's how everything is going to go through very easily. And sure enough, she passed away about a year and a half later, and it did. And I was like, this is amazing. And I'd been a practicing lawyer for 25 years or so, and I didn't know any of this. I was a trial lawyer. And so I became trained on estate planning and started to do it, and I feel really, really good about it.
A properly designed estate plan will give you control of your life and your assets. In most cases, this can all be done without having to go through probate.
Some of the consequences of having to go through probate relate to the time and expense involved. The time is the most important one. Oftentimes it can take months or even years to finish an estate. And in the meantime, that delay could cause damages to some of the property. The executor, the personal representative might want to sell some stock because the market is going down. That person can't do that until he or she is appointed. And if there's a delay in the appointment process, the value of the estate goes down. Nobody has the authority to take care of a deceased's house. And the mortgage doesn't get paid, the utilities don't necessarily get paid. Instead, if you've done your proper estate planning and avoiding probate, within days, if not weeks, of a deceased's passing, all those issues can be dealt with, and you don't have to involve the courts. A revocable trust is an instrument that is written so that your assets can be distributed to whoever you name in the trust upon your death or disability. You name a trustee. Generally, it's the person that drafts the trust that is the trustee for life, so you have control over everything. You're not giving anything away now. But if you become disabled or if you pass away, then whoever you name as the successor trustee will take over and do exactly what's written in the trust in terms of distribution of your assets. And the other beauty of a revocable trust is, as it's called, it's revocable. It means you can revoke it at any time. You can amend it, you can change it. You can decide if there's a change in your family dynamic that what you originally put in the trust doesn't make sense after 10, 20 years. And you can make changes. So it's a very easy instrument. It doesn't require you giving money or giving the authority to manage your affairs to anybody unless and until you get to a point where you're unable to do it for yourself.
Creating customized strategies based on the unique aspect of each case will result in substantial savings to you and your family.
The estate planning process, of course, starts with a meeting with your attorney. And in that meeting, you have to have an open and frank discussion with the attorney about your family dynamics, your assets, your concerns as you grow older, what kinds of later in life living you want to have. And you can begin to plan through that interaction with the attorney to draft documents that do that. Now, when you have these discussions with your attorney, one thing you ought to keep in mind is, of course, who I want to have the responsibility for doing all this stuff, either as trustee or, if it's a young family, guardianship of young children. And that's a very complicated discussion. And when you determine who those people should be, before you do the documents, you should go talk to them. Make sure they're comfortable with that role. Make sure that you're comfortable with what they would do in that role if you're not there to do what you need to do for yourself. So that includes a healthcare proxy, that includes a young family taking care of children. So once you've made all those decisions and you communicated them to the lawyer drafts the appropriate documents. The documents are signed, witnessed, notarized, and generally most law firms will bind them in a package for you to take home with you. It's a preferred idea to have the original stay in a law firm in a safe and have copies distributed. It's really a good idea to give those to the people that are going to be administering your estate. A healthcare proxy is extremely important for anybody to have. A healthcare proxy, like a living will, directs who may make healthcare decisions for you if you're unable to make or communicate your own healthcare decisions. And in the healthcare proxy, you lay out how you want to be cared for if you get ill. A power of attorney is a fairly simple instrument that gives somebody the authority to manage your financial affairs if you're unable to do so. Somebody that you trust will be able to, if you get sick, pay your bills, transfer money, things of that nature. An online legal service gives you templates to prepare documents. It doesn't provide any mechanism for advice and understanding of a family's needs. There are a number of things we can learn online through the internet, through YouTube, but ultimately, being online doesn't have the capacity to ask you questions and elicit information that is important in the analysis of what you want to do. Some of the process is also the benefit of the experience of a lawyer who has seen a number of families go through the aging process and indeed pass away.
Give yourself and your family peace of mind that your assets will be distributed according to your wishes.
In my view, estate planning is really the ultimate manifestation of that old expression, an ounce of prevention is worth a pound of cure. It's something you really should think about and focus on when you have the flexibility to do so. To be able to go through this process ahead of time and not have to worry about it and deal with it while you're grieving the loss of a loved one is really remarkable.
For more information about the Nebenzahl Law Group, visit the website at neblawgroup.com or see this segment again on thebalancingact.com.